Hey, Tracy Earle here, and from Notable Nonfiction. And this week I'm talking to you about the international treaties that we all need to understand. The first one and the most important one is the United Nations Universal Declaration of Human Rights. It was passed in 1948 after World War II. And for writers, the most important one is Article 27, Paragraph 2. And it says, everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. This is really important right now because Canada is looking at their Copyright Act, Europe is looking at their Copyright Act, the UK is looking at its Copyright Act, and we really have to understand that moral rights means your right to be associated with work, that the work keeps its integrity, and if you don't agree, if you work for somebody, even as an employee, you have moral rights, and if you don't agree with the way that your work is revised, you can actually be anonymous and take it away. Actually, you can be anonymous no matter what. You have the right to be anonymous in Canada, which is actually anomaly. Not all countries have the right to be anonymous. Now, this is not a comprehensive right. Michael Snow actually tested this. He took Eaton's to court because they put red bows around the necks of his artwork for Christmas, and he did not appreciate that, and he took them to court. But the court said that they had the right to do that if they wanted to. Canadian and in the rest of the world, for example, France and the Netherlands, they have fair payment laws for creators. Canada does not have anything like that. This is something that we could really fight to get. But we also have something that's kind of, we have no explicit protection from frivolous lawsuits by deep pocket corporations. Some of the other organizations, some of the other countries in the world have put together legislation like that, particularly France and the Netherlands, always France and the Netherlands. We also have something really weird that I haven't been able to find anywhere else, and it's called Crown copyright. And this is actually it constrains the use of government created materials by taxpayers. So I'm not exactly sure why that was passed, but that's something odd. When you are arguing for this, basically you're the right to profit from your own work, you're using a clause that was passed under the United Nations Universal Declaration of Human Rights. And there was also a Paris Convention on Industrial Property, signed in 1925 and amended in 1967. And this is in part what Germany used to pass its law on forced negotiation and bestseller clauses that was later adopted by the European Union. And actually, the European Union is in the midst of discussing the copyright declaration now, and that would include these clauses if it goes through. But I know that there are some clauses that are many countries are against them, so I don't know if that will actually go through. It looks like it probably won't go through before the election in May. Anyway, the Paris Convention on Industrial Property is important to writers because it is what the government could use to create legislation to protect individuals from the exploitation by companies. So bestseller clauses mean that if a work sells better than the remuneration paid to the original author, then that author can actually take that company to court. That's in Germany, I think it's in Spain, the Netherlands, the United Kingdom, France, Greece, Germany. They actually, it's interesting, some of the clauses say that creators must participate in all revenue streams that a publisher creates. So for example, there are several publishers in Canada that have set up copyright contracts with authors, and then they've gone ahead and created movies out of those works, and that was significantly higher than the original writer was negotiating for. And if that happened in the United Kingdom or if that happened in France or Greece or Germany or even Spain, then there would have to be a new contract set up for that. Now, the other thing that's interesting is actually the United Kingdom and in Australia, they have really limited their access laws, and they only allow access for disabled groups for materials unavailable license. All the education sector has to get a license. Any sector in the government has to get a license from the creator. They really have gone much farther than Canada has in protecting the rights of authors, so that authors decide what can be used, not the individuals. Now, the other thing that we might want, actually, that moves us right on to the Berne Convention for the Protection of Literary and Artistic Works. This was ratified by 10 countries in 1886, and it was because of Victor Hugo in Paris. This is the backbone of everything that we do, and the kinds of things that we could get is we could request that the law define contractor and prohibit assignments of copyright in favor of written limited licenses, so that subsidiaries would be forced to put whatever they wanted in writing, with all licenses automatically terminated within an established period of time. Now, I actually would go even farther than that. I think that I would like to encourage Canada to create 3 types of rights. Right now, the Copyright Act in Canada covers moral rights and it covers copyright. I would like them to create a third right, an author's right, which would take all of the rules as they are now. So in Canada, we have some really interesting rules, because if you die 25 years after your death, there's a transfer right, so that your heirs automatically get all your copyright back, and so they can make new deals. So copyright lasts for the life of a writer plus 50 years, but the last 25 years, it's the heirs that determine what will happen with that right, with whatever work an author left. I would like them to give that in as author's rights, or droit d'auteur as it is in Quebec, and then I'd like them to create another copyright, which is actually a commercialization right, and that would only last for 10 years maximum. And so that would mean that all creators would get their work back after 10 years, no matter who was exploiting it. This, I would like to call it the Leonard Cohen Act, because he lost the rights to Suzanne, and I think that, I mean, he's dead now, so he won't get it back, but his heirs could if they would pass this law. I really think that 10 years is long enough for a company to exploit something, and that they should make an agreement anyway if they want to keep the work. So the Copyright Directive in the UK is also talking about revocation, and revocation means that an author can actually take their work back after a certain amount of time, or any time after a publisher stops promoting it. And Spain and Lithuania writers get multilingual rights back if a publisher hasn't used them. So there's all sorts of really interesting rights in Europe, and North America has not followed these rights, and I really hope that they will. There's actually, the important thing is the Marrakesh Treaty, which Canada ratified in 2016. And this facilitates access for people who are visually impaired. And so I think you're going to be seeing a lot more materials available for people who are visually impaired in Canada, thanks to this treaty. And so this is how international treaties really matter to writers. The other ones I want to mention, but that I don't consider as crucial to us, is NAFTA, the World Trade Organization Agreement on Trade Protected Aspects of Intellectual Property Rights, or TRIPS. That was created by the Patent Cooperation Treaty in 1986. Canada signed in 1996, and Article 3 requires members to provide the same protection to citizens of signatory countries as to their own nationals. I'm not sure how I feel about this, because it means that corporations with copyright can actually get the same rights as Canadians. I'm not sure how I feel about it, but anyway, it is what it is. There's also the Belgrade recommendation by UNESCO, and this Canada signed in 1980. The important clause in that one is that artists must be compensated for the use of their works, including the public lending of them. And this is what created the public lending rights, that if you are a creator in Canada, you should sign up for the public lending rights, because this gives you minimal payment, but still payment for the use in libraries and other public uses. Now, the interesting element of this one is that most public lending rights cover all nonfiction books. And now this would require a higher budget in Canada if this were done, because it actually is really important for all nonfiction books should be covered. In Canada, only literary nonfiction is covered, and no practical manuals, no cookbooks, but all of these things are used in the public and to a great deal. So I think that they should actually be covered under public lending right. This particular recommendation treaty created in the United Kingdom, France, Germany, Denmark, the Netherlands, Greece, and Luxembourg, all of them have income averaging for artists. And the United States, Great Britain, and Australia all provide core funding for cultural charities. So this includes all of the writers' groups that we belong to. So, and Quebec, as a result of this treaty, they created in 1987 and 1988, they created legislation that allows a copyright exemption in your income taxes. I think the federal government should consider doing this as well. Manitoba, I believe, did the same thing, as did Ontario. And I think it really is important for writers to get benefit out of the public lending of their works. Obviously, some people want their work to be completely public right from the beginning, but there's no reason why they can't benefit from that as well. Then the UNESCO. UNESCO stands for the United Nations Educational, Scientific, and Cultural Organization, by the way, and they did a convention on biological diversity. And this is interesting for writers only because signatories must respect, preserve, and maintain knowledge, innovations, and practices of indigenous and local communities. And so I think that this particular, for sure, Indigenous writers need to concern themselves with it, but those of us who are involved in our local journalists may actually benefit from this as well. And they also have, UNESCO does, they have a convention on the protection of the diversity of cultural contents and artistic expressions, and the clause that affects us is to preserve the right of states to maintain or adopt the appropriate measures to the development of cultural expression and to the promotion of cultural diversity. I don't believe Canada has done anything particular with this treaty, but I don't know everything. So if you know of something that this treaty has revolved in, then I would love to hear about it. And what I'll do is I'll set up in the show notes a giveaway so that you can have a copy of my notes about all of these treaties. And if you have more information about some of the treaties and some of the laws in other countries that help writers, I'd really appreciate to hear from you. As you know, in 1997, the Canadian government passed some copyright. They revised the Copyright Act so that we lost a lot of benefits from from the educational system. A lot of our work can be used in the educational system without pay, and since the educational system in Canada is massive compared to the number of artists, I think that's really hurt us. And so maybe some of these treaties could help us get some sort of balancing legislation to offset that loss. And the Copyright Act is being revised, and so I encourage you to pay close attention to how it's being revised in Canada. And talk to you next week. Bye.